Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to learn about the importance of the Section 21 of the Indian Evidence Act. You all know Section 27 of the Indian Evidence Act. Section 27 says the recovery part definitely is admissible. Of course, not the confession. Confession is not at all relevant in the eye of the Indian Evidence Act. Confession made before a police officer, confession made in the presence of the mediators, confession made due to coercion, all these things are inadmissible, they are irrelevant. But the portion regarding the recovery of the property is admissible under Section 27 of the Indian Evidence Act. So please remember, if the recovery of the weapon from a hiding place which is exclusively known to the accused and which is not at all known to the other accused, definitely it is a very good piece of evidence and it will be corroborative for giving conviction to the accused person. Therefore, the appeal regarding the conviction is allowed. So, the conviction is confirmed. So, Allahabad High Court, Justice Kaushal Jayendra Thakur, Kaushal, two judges which Justice Kaushal Jayendra Thakur and Ajay Tyagi, while dealing with the case of Anurag Sharma versus State of Uttar Pradesh in Criminal Appeal number 3603 by 2018, dated 6/8/2022, held that if a place of hiding is exclusively within the knowledge of the accused person and the place cannot be within the knowledge of any other person, such recovery is absolutely reliable. So therefore, the conviction is upheld. Actually, the ADJ as Kanpur has ordered life imprisonment to him. So this conviction is once again confirmed by the Honorable Allahabad High Court. Actually, 2018, the Allahabad, that ADJ gave conviction, and 2022 it was confirmed by the High Court. Please remember, this relates to crime number 64 by 2015 under section 302 IPC of Kotwali PS of Meerut district in Uttar Pradesh. Just now we discussed in another video of this so-called minister snatching away the court order and going away. It also refers to Kotwali PS, incidental. Right. Now, actually the appellant, that is Anurag Sharma. Actually, the allegation or crime number 64 by 2015 is that he killed his father with a hammer in the house while the mother was away. The mother was away, and this man, actually he was suffering some mental ailment also. But whatever it is, he killed his father because the father did not give him money for his drugs and also for his drinks. This is the story. At the time, incidentally, the mother was not available. She has gone outside, and by the time she came back, she found her husband in a pool of blood and this boy escaping from the scene of offense. He has already fled away from the scene of offense. Right. The deceased father's name is Prem Kishan Sharma. Mother is Shaila Kumari Sharma. Actually, she reported the matter. And basing on her report, this crime number 64 by 2015 was registered, and the accused person was arrested, and actually they have recovered the so-called hammer by recording his confession under section 27 of the Indian Evidence Act. Right? So actually this hammer was kept in a box adjacent to the kitchen, and this hammer is having blood stains also. Very perfect evidence. Now please remember, now as far as the appeal is concerned, the matter came before the Allahabad High Court. The contention of the accused person or appellant is that the recovery is totally false. Normally all of us will say the same thing. The recovery is false, and he is 60% handicapped and he is not a drug addict. So actually he was having some ailment. For that he used to take the sleeping pills, and this was taken as a drug addiction. It's not correct. Right. So important point, crucial point now we are coming. The mother in her chief examination stated that she gave the FIR. But while in the cross-examination, she turned hostile. She said she did not know whether her son killed her husband or not. Like that, she turned hostile. She was declared hostile. But the FIR was marked by her because it is her signature, maybe LTR signature. And actually, in the chief examination, she stated that when she went to the house, she found husband in pool of blood. Accused has gone away. These facts are 100% corroborated. She has admitted. But during the cross examination, she has turned hostile. But this part is 100% taken as evidence. Even though the other witnesses turned hostile, basing on the recovery and the Panchayatnama assisted by the mediator, attested by the mediators, as well as the PM certificate. So basing on these facts, the Honorable ADJ convicted the accused. Now here, the important point is, please remember, whenever you say that you are the negative evidence, that you are not a drug addict, according to section 106 of the Indian Evidence Act, so please remember, the burden of proving that the particular fact, especially within the knowledge, should be by the accused person. But he could not produce any evidence. Simply he stated that he is not a drug addict and he is taking sleeping tablets. That's all. So court did not agree. And second, the place of hiding is only within the exclusive knowledge of the accused. Otherwise, nobody will think that it was kept in the box. It is not within the knowledge of anybody. So therefore, since no others knew it, and since the places of hiding is only within the exclusive knowledge of the accused person, the recovery is accepted, and therefore the conviction is upheld. So very good case for conviction. So the prosecutors who want their case to be convicted, so please refer it this case. This is Anurag Sharma versus State of UP. Thank you.